which highlights legal now that is timely justice. The new law prescribes timelines for completion of investigation, inquiry, trial and appeal and other proceedings. Participatory role of victims has been enlarged and they are entitled to information regarding progress of investigation. The other significant change is use of audio-video electronic means for quick and efficient dispensation of justice. Service of summons, supply of documents and communication of orders may be made through electronic means. BNSS gives statutory recognition to examination of witnesses, particularly officials and scientific experts, by a video linkage from a designated spot. Witnesses may lie, but circumstances do not. Is all put at face. Our experience in administration of criminal justice shows many a worthy prosecution meets its Waterloo owing to hostile witnesses. A culture of compromise prevails in society, and eyewitnesses due to threat, coercion, or otherwise are unwillingly deposed. In such situation, the prosecutor has to depend on telltale clues like fingerprints, footprints, etc., at the site of crime to nail the offender. These clues at the crime spot have been accurately described in the forensics scientist Callcutta as silent witnesses to prove a crime. They bear new testimony to the identity of the criminal. Collection of such trace evidence like fingerprints, footprints, etc. has been made mandatory under BNSS. This would go a long way to attain the ultimate goal of unraveling the truth and punishing the offender. BSA is the new adjective law on evidence. The law is also contemplates and uptake words of colonial favor such as dominion, commonwealth, or majesty's government, etc. have been deleted. The law adopts a technology-prone approach by expanding the definitions of documents and evidence to include electronic records, marking a traditional shift from paper-based documentation to electronic form of communication and data storage. To leverage the use of technology in collection of evidence, the scope of primary evidence has been enlarged, focusing on proper custody of digital records and preserving its originality in various storage scenarios. Scope of secondary evidence has been enlarged, and the matter stored in semiconductor memory is also deemed as secondary evidence. Nature of certification has been clarified. In addition to the certificate of the person in charge of computer system, certificate of expert regarding matching hash value of the original and digital record has produced has been made mandatory to prove the change of custody and authenticity. I am sure the technical sessions would be educative and lively. They would give clarity and better understanding of the new laws and enable all of us ask the responsibility for their implementation to achieve a fair, just and responsible criminal justice system. Once again, I thank the Honorable Minister and the Ministry for giving me this opportunity and particularly choosing Callcutta as the venue for the third conference. I am sure this large gathering who are here would be benefited by the three sessions which are going to be carried by one of the finest three judges of the Callcutta High Court, and at the end of the day, definitely they will take home a lot of material which will help us in administration of the criminal justice system. Thank you. The Honorable Minister of Law, Acting Chief Justice, High Court of Jharkhand, Honorable Justice Jharkhand Bakshi, Honorable Justice Jitanshu, and Honorable Justice who will be chairing three of the sessions in today's program. Honorable Judges of the Callcutta High Court, Honorable Judges of the High Court of Jharkhand, Orissa and Patna, Dr. Rajiv Mani, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Dr. Rita Rossis, Member Secretary, Law Commission of India, Dr. Anjula Rana, Additional Secretary. At the outset, I am thankful to the Honorable Minister of Law and Justice and the Department of Legal Affairs, Ministry of Law and Justice for inviting me to the inaugural session of the conference on India's progressive path in the administration of criminal justice system. outset, on behalf of my brothers and sisters judges of the Callcutta High Court and the Registrar and the Honorable Registrar, I extend a warm welcome to the Honorable Minister and the other dignitaries on and off the dais in the city of Georgia. The conference could not have been better timed as our country is about to witness the most significant change in the administration of criminal justice system. Since 19th century, the criminal justice in India was administered to the laws made by its colonial masters. No doubt, the laws have achieved their goal and the country was governed through them for more than 1.5 centuries. However, their origins lay in Western jurisprudence, particularly the French law, prevalent in those times. Indigenous penal laws were ignored. They were products of process of Anglicization of the legal system, which Henry Manista, the former governor of Bengal, commented as planting the English hope on the banks of Kubi. India has gained independence for more than 75 years. The country has undergone a sea change since the 19th century. Globalization, advancement in technology, and most particularly, information revolution through the use of computers and internet has generated transformative changes in society. Law, like the proverbial tortoise, must keep up with the fast evolving societal demands. The enactment of the new penal laws is the need of the hour to meet societal needs and aspirations, as Lord Tennyson would say, the old order changes, yielding place to new, lest a good custom should corrupt the world. The BNS, BNSS and BSA have been enacted and will come into force on 1st July 2024. They replace the Indian Penal Code, the Code of Criminal Procedure and the Indian Independence Act, respectively. Their nomenclatures elucidate the legislative emphasis on a justice-oriented, victim-centric judicial system. Let me give a few examples. The word Nyaya replaces penal in BNS. Nyaya is justice in a normal and ethical sense, in contradiction to niti, that is positive law. By substituting the word penal with Nyaya, the legislature intends to formulate a criminal justice system based on justice to all stakeholders instead of a narrow penal concept of punishing offenders. Similarly, reference to narrative in BNSS places the rights of individuals, namely access to timely justice, witness protection, and victim compensation at the central stage of procedural law instead of state power. All the laws will be discussed right back in the following sessions, and I will just restrict myself to a few introductory remarks. BNS has introduced progressive changes in penal law. Offences against women and children have been exclusively categorized in a separate chapter. New offences like organized crime, petty organized crime, snatching and mob lynching have been added. The growing menace of international and domestic terrorism has led to incorporation of Terrorist Act as an offence in general law in addition to the special law, namely UAP. Taking note of the decisions of the Honorable Supreme Court in Navdeep Singh Johar and Joseph Shine, unnatural offences and adultery have been deleted. Binary concept of gender has been diluted by including transgender as a separate gender identity. In offences like procreation of children and importation of girl or boy from foreign country, victims have been made gender non-specific, whereas in other crimes such as assault or criminal force to women with the intent to dispose and voyeurism, gender of the offender is no longer relevant. These changes make the penal law sensitized to modern day crimes in evolving a paradigm of gender equality. BNS